So during 1933 through 35, all kinds of acts are put into place. As I said, the Securities Acts, the Banking Acts, these are now possession. The IRS starts becoming more prominent. There's different revisions of the IRS code. All of them are called reorganization, the reorganization of 1950. So the IRS code is actually, if you're in Chapter 11 in reorganization or Chapter 13 as an individual, you have to put in a reorganization plan. Isn't that interesting that the IRS code revisions are called reorganization plans? Because the IRS code is the ongoing maintenance of the organization of the debtor in possession. So everything now is brought in under the master corporation of the United States as the debtor in possession and made as corporate subdivisions. Simultaneously, the federal government, the federal entity, adopts the Uniform Commercial Code. And then during the course of the next 30 or so years, coming out of Metro is those uniform acts that I talked about, amongst which, or chief of which, is the Uniform Commercial Code. So all 50 states adopted the Uniform Commercial Code between 1933 and 1965. Of course, as we know, there were 48 states in 1933, and the 2 were added to get that complement of the 50 that I talked about esoterically yesterday. So by 1965, well, before I say that, the other thing that is key to all of this is in 1934-35, the federal government and then all 50 states adopted or it passed what are called Administrative Procedures Acts. Because the Administrative Procedures is the framework by which the administration of the bankruptcy will proceed. And what it did is it moved everything that had the appearance, because it wasn't constitutional at that point anyways, because of what happened in the 1860s and 70s, but it had the appearance of constitutional structure. At this point, they moved everything under the executive, under the administrative procedures, and made the executive, the governors, and the president as CEOs of corporations administering under the rules of reorganization, which is bankruptcy, which is in admiralty law, the ongoing administration of the debtor in possession, which means that in the states and in the federal, the executive, legislative, and judiciary, having the appearance of separation of bodies and powers, were really all under the executive administrator. Okay, that's why they call each presidency an administration, because he is administering the ongoing maintenance of the bankruptcy. That means the judicial system is nothing more than a system of administration. It is not judicial in actual fact. And in actual fact, every court is a corporation, and it is held by corporate owners. In many cases, the judges are actually the owners of the corporation. So they're just in commerce. So what it really boils down to is if you don't understand commerce, you don't know what is being acted upon you, and you are completely lost. And that's true with most people. So there's very basic fundamentals, and I'm just going to outline the basics because it's a large subject, but it's a continuing subject of education that as you progress, if you choose to take this path of becoming educated, what you want to be is a master in commerce. You want to be a creditor in commerce, because when you're a creditor, you have standing. When you're a debtor, you don't have standing. And so that when you go into an administrative court, if you're a debtor, you have no standing. That means when you're represented by that foreign agent, that bar attorney, you are actually officially recognized as being an imbecile and being incompetent. Okay? Well, yes, for sure. Now, that's an interesting question.
Yeah, it's an interesting question. You have to for a legal contract. It's equal consideration, right?
Yes, and that's
so
true.
If you throw me money for your real property, it's an illegal contract. Right?
Well, yeah, and it goes deeper than that. Yeah, it goes deeper than that, but we are not going to go into that now because that's too much of a subject.
Well,
but
there's no justice society.
Right, it's just settlement. It's settlement of accounts. Okay, but what I am going to address is you ask about a mortgage. I'll use this nice clean yellow pad. Mort. And this means pledge or oath. So a mortgage in French means a pledge of death. Okay, you bind yourself to something that's dead. Now that's an interesting concept that it took me in learning about commerce for the last 10 years, a long time to actually complete and understand. So I'm going to give you the benefit of 10 years of digesting all of this in the next couple of minutes. It's very simple. When the baby is born, see, remember we're in admiralty now, in bankruptcy and so forth. Let me back up a second. Remember, the captain of the ship is the authority under the authority of the admiral. He is bringing a ship on the sea into port. What is port? Port is a doorway. Okay? It's an entry point. You have a passport because you walk through a door from one jurisdiction to the other. So when you bring that ship into port, you have cargo. Okay, that cargo is bonded in insurance. Insurance is an admiralty maritime contract. So the captain is has the absolute admiralty authority. The cargo is bonded by maritime insurance. He has to deliver it to port. If there is an accident or something happens in transit, like the shit explodes, if they didn't if they didn't store high enough, and the ship blew up. The word shit comes from storing the manure for the fuel in transit. Store high in transit. That's where the word comes from. But something happens. They hit rough seas, cargo is damaged. Well, there's something called a bill of lading that holds contractually the cargo as it was delivered in the original port. So the bill of lading checks in the cargo, it goes into the vessel, it goes on the sea, and it enters the port on the other side. If there's damage, the captain delivers to the port master the bill of lading and a declaration of damage to the cargo. When that happens, the port master arrests the ship. The word arrest is an admiralty term. Okay, so he arrests the ship, which means he seizes control over it properly, not adversarially. He simply, in admiralty terms, arrests the ship, because he must hold that ship in his authority and jurisdiction and not allow it to come onto the land until the insurance adjuster comes and adjusts for the damage and settles it. So once it's settled, he can release the ship, and if the adjustment is accomplished and the cargo can come on land and the value relative to the damage is settled and it's done. So when that vessel hits port, what does it do? It comes into the dock and it berths, right? These are admiralty maritime terms. What happens when the berthing vessel, the mother, goes to the hospital under admiralty jurisdiction, under emergency rules, under the administrative procedures of the executive in control of the collateral chattel property that's going to be bonded and bound by the collateral insurance scheme called Social Securities to underwrite the debt monetization of the collateral property. The mother is the birthing vessel who comes to birth, and the baby, which is new collateral being brought into reality, is received by who? By the dock. Under all of this schematic that I've been outlining. So the dock receives the collateral birthed by the vessel, delivers it to the Secretary or the Bureau of Vital Statistics of the state, which is a corporation that has been pledged since the 1930s into this whole scheme as a subdivision corporation, to continue to deliver collateral for the bonding and surety of the perpetuation of the debt monetization system. That then is certified under a birth certificate that creates a security instrument to attach to the collateral. How do you like that? Delivered into the trust structure. There's something in this whole schematic called the Depository Trust Corporation, which Washington D.C. and New York City. Which, yeah, and there's the DTC and there's the DTCC, the Depository Trust Seeding, CEDIN. To seed something is to pass ownership over. So everything that is created under the Securities Acts of the 1930s bonds and binds as the collateral and creates a negotiable piece of paper that's going to be capitalized and held by the true owner, which is the Depository Trust Corporation. So anything that is created as a certificate, a equity share, a debt bond, or a registration instrument, and so forth, has value in the sea of commerce. And so all we are is creating this vast amount of paper with everything we do. From the minute now the baby is born, birthing the vessel, the dock, and bonding it with the birth certificate, the Social Security number. Now it's the case that you can't, unless you absolutely know what you're doing, you can't even take the baby out of the hospital unless you attach a Social Security number to it. Okay? Today when babies are born. So, so they immediately receive it, bind it into the Matrix. Okay? Just like in the movie The Matrix, all the real living bodies were contained in those solution pods and were attached with all the wires to feed off of the life force, the energy. Okay? And then everybody operated in a world of fiction or illusion, a hologram. And they're all corporations, which are fictions in law. Okay? They're all illusions, but everybody's operating as if they're real. So, and it gets deeper and deeper. And as Alice said, curiouser and curiouser. And remember, it was the Red Queen in Alice in Wonderland who was talking backwards. So, well, there's no money. Okay, what there is a basic T-bar of debits and credits. And in what's called generally accepted accounting principles, everything is a zero-sum game. Okay, this side has to balance with this side and end up with zero. Where you have a balance sheet of assets and liabilities, it has to end up at zero, correct?
She's talking about the trust.
No, she's talking about, well, yeah, but I don't want to get all into that today because it's very deep and complex, and it'll really confuse more than enlightened, so let's not go there today. But in very simple terms, we are pledged as the bonded collateral. Back to that original thing I talked about yesterday, religion, to bond again, to bind again, to this ultimate goal of creating the law of the king and the priest, or the line of the king and the priest, land and law. Here is the line of the priest. The Hudson Bay Company down to Metro, creating uniform commercial code rules that are going to apply to how things in commerce are operated relative to delivery of goods, warehousing of collateral, warehousing of inventory, settlement of accounts, securitization, settlement of obligations and or things like judgments and so forth. So what it really boils down to is that everything in the system is commercial. In fact, by 1966, Congress passed an act called the Federal Tax Lien Registration Act. And on page 3722 of that act, there is a statement which essentially, it may not be verbatim, but essentially says, henceforward, all matters pertaining to taxation and monetary policy shall be under the purview of the Uniform Commercial Code. Why 1966? Because by 1965, two things were accomplished. They took all the silver coin out of circulation, and all 50 states had adopted the UCC. So now there is nothing left. There's only legal tender, and tender is a commercial term. Okay, when you tender a payment or tender something as payment, it's an act in commerce, and in commerce is a very simple formula: offer and acceptance. Then there is variables on the side of acceptance, which has to do with either two other simple things: staying in honor in commerce or going into dishonor. So what we always want to do is be in honor in commerce. For one thing, that's why they use the phrase for the judge, your honor. It puts him in honor, it puts us in dishonor. So we never call the judge your honor. We might call him asshole, or we might call him, hey, schmuck, but we don't want to call him your honor. Well, they may, but that's their problem, not yours. Okay. But see, the court, huh? Yeah. But you have to know what you're doing, and you have to understand these rules. You have to understand when you cross the bar, you know how the court is set up, that there's this little wooden gate. That's the bar. You cross the bar, you've entered into his commercial zone, onto his ship. He's the captain of the ship. But there are rules in commerce, and there are rules in battle, because you are in battle there, of how to comport yourself. And then there are maxims of law. For instance, in the one maxim of law says, he who leaves the field of battle first loses. So when you engage a process in commerce, you never want to leave the field until you conclude your business. So, and that's these are just basics. We don't have time to go into that, but simply stated that, remember I talked about the myth of ISIS claiming Ra''s power, Amun-RA or Marduk-Ray's power by capturing his name, because that is who we are. That's our unique signature. It's like when Richard shows the pictures of the orbs. There's a dot of red, which is the unique resonance or unique sound quality tone of the signature, because sound precedes the light. Light is secondary manifestation, because we are pure resonance, pure sound. And we've been tricked into the illusion of light. That's why the light is the processing center. And I'm going to get into that in the last phase of things. But so when we say our name, we are speaking our unique sonic signature. And so that myth of ISIS and capturing the power of Amun-Ra, or Marduk-Ra, was capturing his name. The same thing applies in court. When you go into court, they want you to identify your name. But what they're looking at on their piece of paper is an all capital letter name, which is the straw man that's been created as a type of a trust in their system that I've been describing. So if you'll notice, if you look on any legal document, a notice from the IRS, a traffic ticket, a tax bill, a utility bill, anything, your name is always in capital letters. Now, there's something in the United States government called the Government Style Manual. You can order it from the government printing office, and it tells you precisely the rules of language and English grammar that will be followed in any and all documents issued by the government under administrative rules of everything I just described. You will only find one place in there that describes the use of an all capital letters name. It's the name of a vessel. It's the name of a ship. Okay, USS Enterprise, or the USS Lollipop. Mm-hmm. So when the straw man is created, it's an alter ego. It's a fiction in commerce attached to the birth certificate that's going to be bonded and insured by the Social Security construction, which is the insurance underwriting the commercial paper, which are debt obligations called Federal Reserve notes. And and it is a vessel in commerce, a vessel that the foreign agents, the bar attorneys, under letters of marque can board to capture under letters of marque and reprisal that I described earlier, to capture the booty, rape and pillage, and take what they want. So everything is pledged collateral. That's why